5 seconds to go. Start. Supply of relied on documents based on which the law has been set into motion would meet the requirements of the principles of natural justice. Stop. No court can compel the authority to deviate from the statute and exercise the power in altogether a different manner than the prescribed one. Stop. Para. As noticed, comma, a reasonable opportunity of being heard is to be provided by the adjudicating authority in the manner prescribed for the purpose of imposing any penalty as provided for in the Act, and not at the stage where the adjudicating authority is required merely to decide as to whether an inquiry at all be held into the matter. Stop. Imposing of penalty after the adjudication is fraught with grave and serious consequences, and therefore, comma, the requirement of providing a reasonable opportunity of being heard before imposition of any such penalty is to be met. Stop. In contradistinction, comma, the opinion formed by the adjudicating authority whether an inquiry should be held into the allegations made in the complaint are not fraught with such grave consequences, and therefore the minimum requirement of a show cause notice and consideration of cause shown would meet the ends of justice. Stop. A proper hearing always include, comma, no doubt, comma, a fair opportunity to those who are parties in the controversy for correcting or contradicting anything prejudicial to their view. Stop. Para. The High Court interfered with the show cause notice impugned, even though the court found that there was nothing on record to indicate that the adjudicating authority had considered certain aspects adverted to by the noticee, comma, before forming the opinion to proceed further with the inquiry. Stop. However, comma, a communication calling the petitioner in that case for a personal hearing was set aside, and the special director was directed first to form his opinion after recording reasons, comma, whether to proceed against the petitioner with regard to the impugned 11 show cause notices. Stop. Para. In Amit Jain versus Securities and Exchange Board of India and another, comma, the Delhi High Court held, para, it is apparent from the above that the formation of an opinion by the board that there are grounds for adjudging under any of the provisions of Chapter 6A of the Act is a precondition for appointment of an adjudicating officer. Stop. It follows that in absence of such an opinion, comma, an adjudicating officer cannot be appointed, and any such appointment would be without jurisdiction. Stop. The respondent also does not dispute the above proposition. Stop. It claims that the board has formed an opinion that there are grounds for adjudging under the provisions of Chapter 6A of the Act, and, comma, therefore, comma, the appointment of the adjudicating officer cannot be faulted. Stop. In its counter affidavit, comma, the respondent has averred as under, para. It is submitted that SEBI had examined into the alleged irregularities in the trading in shares of Himalayan Granites Limited and into possible violation of the provisions of the SEBI Act and PIT regulations. Stop. Further, comma, the adjudication proceedings were initiated in the matter after the whole time matter. Stop.